Thank you very much, Surya. We have about 25 minutes for discussion. So the floor is open. Questions or comments to our panelists? One, please.
Thank you. It was very interesting, and this topic is I think it's at the core of this question. I think for Tineka, Tineka mentioned exceptions, and she said that some fields of law we already have widely improved regulation. So if you can elaborate on that.
Yes, briefly. Interesting was, but all our findings still have to be verified by the authors of the mapping papers. But very interesting was that in China, for instance, it was said that the definition of a group included a statement something like that, that the articles of association of a group should be in place. So that is one thing that I found very interesting for groups. Germany, Slovenia, they have sort of group law distinguishing between equity groups and control groups. Sorry, between equity groups, economic groups that are based on equity relationships or pursuant to contracts between the entities at the one hand, and at the other hand, factual groups. And within those type of groups, it is allowed to have one common objective and to also impose that on subsidiaries. And subsidiary directors should not be held liable when they follow the group purpose, the common group purpose and objectives. I think, but I was really looking from the corporate governance perspective, like what can I find in all those company laws to see how you manage a group. What instruments are there? Is there any body of group law? Are there any instruments that a top parent company can use to implement a climate change program? And then when I'm thinking about the liability aspect, I'm looking at Lynn. Maybe you can say one or two sentences about that, or maybe give a comment on that. What we found in the mapping papers on liability of groups, because the most interesting one was, of course, Albania, but that has been elaborated.
Yes, we looked at the piercing of the corporate veil doctrine, of course, that has been mentioned in the various mapping papers, and what we find is that there are very few jurisdictions having clear criteria to this approach. So basically, we're left with a doctrine where it's very hard in advance to know whether we can hold parent companies liable or not. And this is why we find it very interesting to look at Janetay and also the Turkish Companies Act, which are addressing or giving clear criteria to hold the parent companies liable, and also in an extraterritorial context. In addition, we also then look at the possibilities of the foreign direct liability cases that we can see.
Maybe you want to say something more about Albania.
There's one more thing that I think is important, because it seems to me that it's all very well talking about subsidiaries, and I'd like to get rid of them, of course, that's not enough, because we've got other sort of structures as well, because I remember there was an Alien Tort Claims Act against McDonald's, and of course they didn't, the plaintiffs didn't win because McDonald's is a franchise. So we're going to have to deal with that as well as, I suppose, special vehicles and joint ventures as well. So, I mean, subsidiaries, we've got to keep going. We have more. I mean, we've got to do more. And the idea that you can just have corporate social responsibility to dealing with these big multinationals is crazy, because they are so powerful, and there's no doubt that they are about profit. And that's what else are they doing? I mean, these structures are deliberately doing exactly what Mark was saying. No obligations, but a lot of profit.
The gentleman at the back, please.
Yes, thank you. Another topic and question for China time. You mentioned that you would like to get rid of the subsidiaries, the branches. My background is financial services law, where branches are familiar with institutions, for instance, which give them, for instance, a UK bank a possibility to provide services in 30 other countries in Europe. So basically the motive for this has been that the banks are under supervision in their home country. There is a license obligation, and they can provide services via the branch, which doesn't require much capital in the host country.
So those are branches, yeah?
Yeah. They're branches. So the interest, I understand, has been that the parent company, the bank, has benefited from this. It has served the interest of European integration. So my question is, even if this is not the angle of today's topic, that what would be the beef for the parent company to set up branches in the company? What's the gain for the parent company?
Yeah. Well, I think the answer would be that they'd be like a sort of department. Either there's they would be they would not have legal personality. So you could get rid of half of the lifting the veil issues. So they would be branches. So it's a question of it's one way of lifting the veil using branches rather than companies and subsidiaries. That's all.
Next question, Beata.
We have Surya with us on Skype. I'll use the microphone. I think these presentations have been so interesting, and this research is so important, and in one way the most difficult part, because one thing is regulating the entity that is recognized by law, but another is regulating, dealing with these entities that, according to company law, are not at all in the way that they obviously are in practice. So we have this, as Tineke said, this disconnect between control on the one hand and responsibility and liability on the other. As many of you probably know, there is a suggestion, there is talk about codifying the possibility that is now very clearly there in practice, that the parent company should control the group and that the subsidiaries should promote the interest of the group, and that has to be complemented with liability, otherwise we're codifying something really unsustainable. I just wanted to add to the piercing of the corporate veil that there are some indications, for example, here in Norway, that there may be a new thing starting with an environmental piercing of the corporate veil with totally different conditions than there are for ordinary contractual claims. Thank you.
Was there a question in the second row? Yes.
Thank you. Which one is it? Does it work? Both work? Okay. I thought I really liked the presentation. I really liked this topic as well. When we talk about corporate groups, then often a parent company at the moment I have a feeling, is a bit in a sort of a catch-22, in the sense that if we look at liabilities or potential liability in court, we look at, have you interfered? And if you have interfered, well, then that can be a reason to hold you liable. So I was really happy that you suggested, well, we also have to see if they have interfered, if we would put in the presumption, if they have interfered, then we'll look at, have they done, do they have a due diligence in place? Do they have a procedure in place so that they have done everything they could do in order to take away a potential liability in order to take away negative consequences. At the moment, if you look at competition law, for example, and the liability of a parent company, then there's not that much leeway and not that much room to actually say, well, okay, we have interfered, but we've also done a lot to make sure that bad things did not happen. And in that sense, I think it can be quite tricky for a parent company, and there's a bit of a perverse incentive at the moment, because you know that if you interfere, the chances that you might be held liable are bigger. So I was wondering, when you talked about the due diligence part, what if you have thought already about what can we then expect of a parent company? Like how far should a parent company go in that?
That was a question to you, Surya.
Okay, yes. Let me see if I got the question right. We are talking about the catch-22 situation that the parent companies face. Should they intervene and control the subsidiary or not? If they do not do it, then they might say there could be a liability. If they do it, again, there could be a liability, right?
Well, yeah, and I was also looking forward to what you came up with. You said at the end of your presentation, well, we should put in place a presumption that the parent company can be held liable, but there's a way to rebut the presumption. I was looking for, if we give them a possibility to rebut the presumption on the basis that they have done a lot of things, they have a lot of compliance mechanisms installed, how far should they have gone then? What can we expect?
Okay, let me try to respond to this. I think this is a work in progress, and I think later on detailed guidelines would have to be developed and evolved by the courts and by the academics in terms of due diligence within the corporate group. But the basic idea that I'm proposing is that let us change the rules of the game. Now the rules of the games are uncertain. In some cases, which are very minor cases, like minority of cases, the veil could be pierced, or the parent company could be held accountable under the Chandler principle or something else. In a great majority of cases, the parent company is not liable. So if we have this common presumption that the parent company should, as a rule, be considered accountable for the misbehavior, and I think I did not mention it in my presentation, but I would like to make a distinction between financial operations of the company as well as the non-financial ones. When life and liberty is at stake, and that's why I will differentiate the situations of creditors and all this. Of course, right to property is crucial, it is a human right. But I'm more worried about those cases where life and liberty, there is cases about environmental pollution or human rights violations. So what I'm proposing, this presumption is only in these later kinds of cases. I'm not applying it at this point of time to all sorts of cases, but this is something which is open for discussion. Once this presumption is there are two stages. The first is that there could always be a possibility that the parent company does not know what is happening with the subsidiary, because we are operating at a physical distance. And despite the technology and all this, it is quite possible that the subsidiary may be hiding certain things. And I think then it will be unfair to make the parent company accountable. But what the parent company should still be doing, it should take some steps which are reasonable in the facts of the case to find out and investigate that what is happening. If it just sit idle and just reaping benefits out of the subsidiary, in my view, that is immoral and unethical, and that should be stopped by law. But if it has taken reasonable steps, and despite those reasonable steps, the violations still took place, then that could be pleaded as sort of a mitigating factor, or at least as a partial defense, and then the parent company could rely on it. That's what I meant. Thank you.
Thank you, Surya. I believe I have David, is it? Yes, the floor is yours.
Yeah.
What would be the argument, the legitimate argument? This is just about externalizing risk, right? Protecting parents from risk. Is there anything
I was going to have this question for the audience, please, to say exactly precisely that. I mean, what is this structure? Why do we have these structures? What are they for?
A possible claim could be that the separate group thing allows outside investors to take minority positions in subsidiaries without exposing themselves to risk. But limited liability is already supposed to be.
Exactly. It's a double bind. Yeah. Good. Thank you.
Can I respond?
Okay.
Of course.
Can I respond?
Okay, I have actually a couple of two-finger follow-ups to this discussion. So why don't we do those quickly, and then I'll come to you, okay? So, or do you want to follow up on this same one? Okay, great. So you're up next. Okay, and then Tineke, and then you, okay? Did you have a question also? Okay. Go ahead, please, floor is yours.
The two cases that Janet mentioned, I think this question is directed to Janet, Petrodol and
Chandler, yeah.
They seem to me to be two cases that are where the courts are going out of their way to avoid piercing the corporate veil. Obviously, Petrodol, the resolution was to say, husbands sold these enormously expensive properties.
It was a fraud, yeah.
So we'll establish a trust.
Yeah.
It's a trust, so we don't have to pierce the veil, which would be the obvious thing to do. But of course, if you start piercing the veil, you start doing things like getting in the way of shareholder interest, because that's what the veil is protecting, those investments. And Chandler, of course, is because Adams put so many barriers between piercing the veil in these cases, that Chandler is the solution to that. What we do is so egregious, but so in these circumstances, we will say that there's but it's so specific, Chandler, and there's so much interconnectedness between the parent and the subsidiaries. It's difficult to see how that would be reproduced in a court case, let alone human rights or environmental issues. But my question is that even if it was, even if you could establish liability there, do you not think that parent companies have been wonderfully protected by the veil for such a long time and pretty safe, don't think they want to? If it does come to the point where the law is actually effective in creating responsibilities and liabilities for the parent company, that they'll simply organise differently.
Yeah.
And then when you get rid of subsidiaries at all, you're still going to have the problems of de facto groups. And surely we need to have some sort of model that not only encapsulates corporate groups, but encapsulates these quasi-corporate groups, or de facto corporate groups as well.
The answer is yes. I mean, it's precisely what I'm saying about franchise and so on. Yes, I mean, they would fiddle it in some way, and there's no doubt that will happen with Chandler, for example. I'm sure the lawyers are beaving around saying, we're going to have it in a different structure. Please, yes, please, it definitely will happen. But I think what we need to know is that we don't want to have these huge structures. It's quite ridiculous. I mean, basically, they're penis extensions. It's a crazy thing. This is a huge thing. And we don't want huge things. I think it's got to be national, it's got to be local, and we've got to have some sort of social purpose to have these huge structural things, particularly because I think democracy is damaged because of that. It's absolutely crucial.
Tineke.
Well, the first answer to David's question is that, of course, creating all those subsidiaries is very important for tax lawyers, for notaries. I mean, we're talking job creation here for lawyers. And it's not a joke, but that's really true.
They could do something else.
But the fact is that those multinationals, they usually have grown in an organic way. I mean, every day something changes in this network of a multinational company. Some come in, some go out, some are split, some are merged, some are demerged. I mean, it's not something that is there at one day and tomorrow it's still there. It changes every day. So to take out all the subsidiaries would require a lot of, that would require a lot of legal action.
That'll be good for lawyers as well, you see.
That's right. And every system, yeah, every corporate law has, of course, its own system of how to register a company and what the duties are. And then you have not only the 100% subsidiaries, but also subsidiaries of 50% or participations of 20%, and you have joint venture companies, and you have contractual ties. So it's not that easy, I think, but that's the more serious answer.
Janet, you'd actually asked, and I had your name on your list, but I assume you responded.
No, exactly. Well, I think we actually agreed.
Okay. Okay.
The question was, is there a social purpose for having these structures?
Right.
Well, I have one more thing to comment. That is, I made my students in both in business classes and legal classes compare the business structure and the legal structure of multinationals. So they all had to select one multinational, and then they could work 4 weeks on finding out how the legal structure is. Well, impossible usually to find that completely out. And then they had 4 weeks to work on the business structure to see what is the business model. Is it a matrix model, or is it a hierarchy, or whatever? And then compare these two. And there is not one multinational where the business divisions relate to the legal divisions. I mean, many multinationals aim for harmonizing the two structures, but it doesn't happen. It's not there yet. So that is an argument for simplifying the legal structure and only look at the business structure and look at the reporting lines, financial reporting lines, and the responsibility reporting lines.
Thanks. You're next.
So I've only been thinking about this for, I guess, the past hour, about what's the purpose of subsidiaries, but coming from the Canadian context, I'm not sure that we would want to get rid of subsidiaries because we have an economy highly integrated with the US. A lot of Canadian companies are subsidiaries of American companies, but under Canadian corporate law, there are requirements that a quarter of the board of directors, and at least one director of a corporation is a Canadian, resident Canadian. So if you get rid of subsidiaries, and again, when we just started thinking about this, do you then have these, just branches with no Canadian representation in the corporate governance structure? Like, would that actually be worse for Canada than our current, parent subsidiary structure?
Janet, do you want to?
I don't know. I mean, it seems to me that you could sue the branch in any jurisdiction, so that would be okay.
But I guess I'm just thinking of, not just the case of when something happens and you want to hold someone liable, but then if you have a company in Canada, I think the idea of having Canadian directors on the board is you have someone on the board who sort of sees himself as being from Canadian interest in what that company's doing. And if you get rid of the subsidiary structure and just say, but still, I don't think you could close our borders to American companies.
But presumably we could have a department which has a Canadian in that particular jurisdiction. That could be done.
Beata, you had a quick follow-up?
Yeah, just a quick follow-up to that. You can't, at least in Norway, I think it's the same in many countries, you can't sue a branch. A branch is not an entity that can be sued or that can sue or that can enter into contracts, anything. It is a part of a company. So that it would just make everything less transparent and difficult. So I think we either have to redesign everything totally from the beginning, which we can't, or we need to regulate what we have. Sorry, Janet.
No, it's okay. I mean, one of the reasons why I want to stop this is because it seems to me that it shouldn't be so big. And I think if we can get rid of these huge structures, then they would become more national or at least regional, and even perhaps, even in real small companies. And so it's going to be different, but it seems to me what we need to do is to have national law, and so the people, you can actually vote. You can have a company law which said, yeah, okay, we'll get rid of this stupid system. Let's see what happens after that. And it seems to me that these companies might be smaller, and I think that might be a good idea.
Okay, we've got just a few minutes left, and so what I'm going to do is take the remaining 2 people I have on my list and then go back to the panels for some last comments and to give also Surya the opportunity to jump in on what he's heard so far. So please, floor is yours.
The question or some general reflections about multinationals once again. You said they are purely operating for profit. And is this really an accusation? Forget right now that all enterprises by their very definition operate for profit. From the point of view of macroeconomics, they are the core issues of economy, which perpetuate economic bloodstream and supply jobs, etc. And to be clear, I agree that departing from pure shareholder value is an idea which is well discussed, but still, the shareholder value does not mean operating for profit. Those are not synonyms. These are different pieces. And in this case, what is really the point of, and what's the way of execution of getting rid of subsidiaries? Once again, you said we hate big things. And once again, from the point of view of economics, if there is a big enterprise that there are more research and these entities also can positively affect the economy. And I think once that if we have branches instead of subsidiaries, the entities would be bigger because the subsidiary is a different separate legal entity. So branch, in this case, the entity, the whole national is much bigger.
Karsten, and then I'll go to Surya first and the rest of the panel. You pass?
This is
okay.
dinner, I think, yeah.
Surya, based on what you've heard, do you have some final comments?
Just sum up what I said, because if we could raise this limited presumption which makes the parent company accountable, I think this is going to promote both responsive and responsible business. I think this is going to be good incentive. So I think we need to go for this. Thank you.
Thank you. Janet.
Very quickly. Yes, I mean, I think that's a very good point. But it seems to me that having a lot of growth is a very bad idea. That's one of the problems. And if you're talking about economics, then they think that that's fantastic. But for the planet, it's not. So I think we want to have small companies so we can stop these huge companies. I'm actually working on a particular book about the inefficiency principle. And I think that's really crucial because I think people need to have jobs rather than a lot of money.
Tineke and then Lynn.
I always wonder why competition law gets so much attention and has such elaborated system of case law, and that really focuses on economic reality as opposed to corporate law. And I'm just wondering, what interests are we protecting by competition law? Okay, that's clear, the consumer choice and innovation and things like that. But I think corporate law can do much better and also protect the environment and human rights and the position of employees by also including some normative values. Thank you.
Yeah, my final comment will be due to environmental liability for multinationals, and that will be an incentive to shift the burden of proof, because up today it's the claimants that are, or the victims of environmental damages, that has to prove whether the parent has interfered too much or what they could do different. So the need for a shift of the burden of proof could be a good incentive so that the parents have to show that they did enough.
Thank you. And join me in thanking all the panelists.